Judge of the Circuit Court of Raleigh County is now sitting. Be seated.
Good afternoon. Court calls the case regarding the May 11, 2010 primary election Democratic nomination for office of County Commission of Lincoln County, West Virginia, Phoebe Harless, contestant, and a Democratic nomination for office of County Commission of Lincoln County, West Virginia, Charles A. Brumfield, contestant. This is civil action number 10-C-75. I'm serving as special judge in this matter. Would counsel identify themselves and introduce their clients for the purpose of the record, please?
Your Honor, my name is Harvey D. Payton. I represent contestant Phoebe Harless, who's seated to my immediate left, and contestant Charles Brumfield, who is to her immediate left, here with me, counsel.
Thank you, Mr. Payton.
Good afternoon, Your Honor. I'm Mike Carey. I'm here with David Pope from the firm of Terry Scott, Douglas and Kessler. We are representing the respondents, Thomas Raymond and Terry Bowman, who are here in person behind me.
Thank you very much, Mr. Carey. All right, I have received a flurry of faxes, and I think I am up to speed in regard to the matters forwarded to the court, although some of the most recent faxes were addressed to Mr. Carey only, and I did not look at those. But I do have the supplemental response of Ms. Harless, and I have the reply memorandum from Mr. Carey, and I have reviewed those documents carefully. All right, counsel, are there preliminary issues that we need to discuss this afternoon?
I don't believe so, Your Honor. My understanding was we were here simply to take up the issue of this summary judgment motion, but...
Anything, Mr. Carey?
Nothing in addition to that, Your Honor.
All right, and that is correct, Mr. Payton. It is your turn to reply to the summary judgment motion filed by Mr. Carey. Do you wish to present evidence or argument?
Well, we submitted an affidavit with exhibits attached, Your Honor, and with some West Virginia case law attached. At this stage, the summary judgment stage, it would appear to me that the issue that needs to be decided is there an issue of material fact relevant to the qualifications of Ms. Harless that would warrant a full evidentiary hearing before the court as a finder of fact. So I believe it would be appropriate for the court to make findings of fact based upon affidavits, exhibits now and faxes, and that there isn't. Frankly, I think Mr. Vance ought to be entitled to speak for himself. That's a really important issue to him. He's a practicing physician, and I assume if the matter were to be addressed at the trial in Lincoln County, he could probably, well, he obviously comes to the courthouse with some frequency because he's a county commissioner over there in Lincoln County. But if the issue, as I believe we've pointed out in our response, is the two-part test of residence or presence and intention of a person regarding the establishment of a domicile or an interruption in that domiciliary state, then that is something that Dr. Vance should be entitled to speak to. It's a very important issue. There are other things involved in that too. I didn't think about it. You know, there's a case that involved someone near and dear to Mr. Carey's heart, Arch Moore, former governor. Remember when Arch Moore tried to run for the third term? He served one term. During his first term, the succession amendment passed. He served a second term. He tried to run a third term, and the Supreme Court wouldn't let him and said, you cannot elect a person who is not constitutionally qualified, and that applies both prospectively and retroactively. I'm not aware of any case that's been brought forth here in West Virginia, but I think as the exhibits we've submitted have abundantly shown, a rash ruling without hearing this case and building a full record with cross-examination, not only of Dr. Vance, but of other people who have submitted affidavits in this case. What are we going to do if the court then interprets the fact that Dr. Vance not meeting the constitutional qualification for office, never lawfully took office. That's just problematic. Particularly, or that if in fact Dr. Vance changed his domicile from Laurel Hill District to Duval District sometime after he was elected in 2000. You got to remember, the property that's the subject of this argument wasn't purchased by Dr. Vance until 2001. He was already a sitting county commissioner and was on the ballot from District 5 at that time. Thereafter, a man named Stowers ran for the county commission, who wasn't undoubtedly a resident of Duval District. One might have to say at that point that Mr. Stowers was not a legal candidate, and therefore never legally took the office of county commissioner in Lincoln County. I don't know what the answers to these questions are. They're not really germane to this argument today, but I think there's something the court should consider in weighing whether to grant or not grant relief in a summary fashion on this issue, which would have the effect of declaring Dr. Vance as now serving and having been serving for a considerable period of time from a district in Lincoln County where there was already a sitting incumbent county commissioner. I wish I knew the answer to that question. I just don't. That's why you're the judge.
Thank you very much, Mr. Payton. Dr. Vance is not here today, and do we anticipate that he will be available at trial?
I would anticipate. I haven't spoken with Dr. Vance, but I certainly intend to subpoena him. And with enough lead time left, he's going to make arrangements with the clinic. He works at a Robert C. Byrd, I believe, Health Center and Hearts Health Center in Hearts, West Virginia, where he sees patients from 9 to 5, 3 days a week, and from, I think, perhaps early afternoon until later in the evening, 2 days a week. Probably we can get him up there Monday or Tuesday or Wednesday, one of the 3 days. I would anticipate that.
And you don't know what his position is going to be, I suppose. I mean, either he made a false statement whenever he submitted his candidacy papers, or he was mistaken whenever he submitted his candidacy papers, or he actually lived within Magisterial District 3 at 12445 Laurel Fork Road. Or I suppose we might have another consideration. Perhaps he was in the process of moving, or he was just temporarily residing there.
Well, I can tell you this, Your Honor. When we were here we were in Lincoln County the last time, took considerable evidence, the testimony, there were exhibits regarding this geospatial analysis of the piece of property in relation to the descriptions from 1986 of District 5, 4, and 3, which intersect in this area. And I told the court that I think I was at least entitled to have an engineer look at it. Well, I did. And the engineer said, well, I think this property drains in an easterly direction towards Mud River. And I'll tell you that, Judge. I mean, obviously, the reason I don't have a surveyor here, if I had one that would say it drained the other way, I'd have him here. I mean, it's obvious. I think that would be obvious to the court and to Mr. Carey. So after several unsuccessful attempts to get Dr. Vance on the telephone, managed to get his email address, and I emailed him and said, is there a reasonable explanation for this? I need a straight answer to these questions if there's any way I'm going to be able to help Ms. Harless in her present case. And I got a response. I didn't make up this affidavit. I mean, the response was, I have always maintained a residence in Laurel Hill, exclusive of the properties that border Laurel Hill. I had a residence at Pleasant View, as well as a residence on Route 37, which both were inside the Laurel Hill District, as well as my residence on 9 Mile Creek, which I rent now. I have always maintained my residence in Laurel Hill. I have always voted in Laurel Hill, as has my wife. On all my candidate papers show Laurel Hill as my address, as does my voter registration. The only time I listed